Today we're going to talk about using independent contractors and what are the trouble triggers that can basically cause audits or claims or cases against your company. So what are the consequences? The chances of getting audited out of the blue is quite small. It's usually about 2% of the total population on a random draw. So that's pretty small, but the chance of getting called in on a claim due to some other action is actually quite high. The four areas that you need to be concerned with are workers' comp claims, unemployment claims, civil actions and class actions, which will be your worst problem, I think, and then routine audits by the IRS, the DOL, and the state tax authorities. So we're going to go through each of those now and see if we can't give you a little heads up on what's coming your way. So, is there a bright line test? Unfortunately, no, there isn't. Each state has different criteria for determining employee status. You got to do your homework. You got to make sure you know how your state operates. When it comes to unemployment, it's all about direction and control. Who sets the hours? Are the rates negotiated? Uniforms, ID badges, right of refusal, all those things. With the IRS, they have the 20 questions test, which is actually 10 questions asked two ways. To determine direction and control. Then you have the ABC test, depending on what state you're in. Is the driver free from direction and control? Is the business different from yours? Is he in an independent trade? Then you have the common law test, which is who controls the driver's behavior, who has the financial control, and the type of relationship, and is there a contract? So the best practice is always to do as many things right versus wrong. With the IRS 20 questions test, if you get 12 right and 8 wrong, you should be okay. Hopefully. Every state agency, ALJ, clerk, they interpret the rules to meet their own personal beliefs, which is unfortunate, but that just happens to be the way it goes. So you could have two judges sitting there, one in one room and one right next door in another room, and he interprets the law one way where the other judge interprets the law the other way, and unfortunately for you, you're going to have to prove your innocence whichever way he wants to go. Now let's talk about the different claims that are going to come up. The first one obviously is the workers' comp claim. Now, workers' comp claims can be very expensive. You get a driver, he gets in an accident, he sustains a big injury. It could cost hundreds of thousands of dollars. He's got a wife, he's got 4 kids, he has no coverage. He goes to some back of the attorney phone book attorney, and tells him he can get him millions. So he files a comp claim, and he's on the stand. He's been very well coached. He doesn't speak good English. He didn't understand the contract. He couldn't refuse jobs, had to work on their schedule. And he'll go on and on as far as the criteria to make him out to be an employee based on what his attorney has told him. A compassionate judge will say, well, we think you're an employee, and possibly so are all similarly situated drivers. So your comp carrier, who did not collect any premium on that particular driver because he was a 1099 independent contractor, well, they're not going to be very happy because they're going to have to end up paying that claim. So what are they going to do? They're going to come back to you and they're going to want to do a back premium audit, and they're going to go back probably 3 years, and they're going to hit you with a bill that's going to be substantial. The solution to this is, you got to contractually obligate each driver to carry an occupational accident policy with a high limit. And your company should purchase a contingent comp liability policy to protect your company in the event of an adjudicated employee claim. And what that policy will do is, if your carrier for your workers' comp on your employees gets hung with a claim on an independent contractor and they have to pay that claim, the contingent policy will reimburse your carrier for that claim, basically so that your loss run should not reflect such a large claim. Now we're going to talk about unemployment claims, and basically you're always going to lose at round 1. So you've got a driver, he decides he's not making enough money, his vehicle breaks down, he doesn't like the dispatcher, he doesn't like some of the people on his route, it's just not the gig for him, so he quits, or even worse, your dispatcher fires him, which is something that should never happen because the word fire does not come up in a conversation with an independent contractor. So he goes down to the unemployment office and he speaks to a clerk there, and he tells them that he worked for your company and he was treated like an employee and he deserves unemployment. perception being reality. If he thinks he's an employee, he's going to play that card all the way through. Why? Well, he needs the money. He needs to pay his bills. You'll get a notice that they granted him unemployment, and you're going to want to dispute that, because if you don't dispute it, they're going to come back and say, oh, how many other guys do you have just like him, and you owe us the back tax on all of them as well. So you're going to have a hearing set with an administrative law judge, who most times isn't a lawyer, he's not a judge. He is a employee of the agency who has been promoted up to the position of administrative law judge. Sometimes you do get real judges. Sometimes you do get judges or ALJs that are lawyers. Not very often. And basically, at this round, you're usually always going to lose, because they're working off the set agenda of the agency. So if the agency says, we as an agency don't believe in the independent contractor model, we think it's a tax dodge, we think everybody's an employee, they're basically going to rule in that favor, and they're going to push for answers from both the claimant and from your representative to try to prove that point. It might come as a shocker, but sometimes these drivers get questioned, and they tend to have very selective memories. They could be persuaded by the examiner to believe he's an employee. A lot of these judges will ask very leading questions to the driver to try to get him to answer the way they'd like him to answer. And I know it's hard to believe, but sometimes they'll even lie to collect an unemployment check. And I can tell you that in all my years of doing this, I have seen more claimants sit on the stand and outright lie about their particular situation. And what happens to them in the end when it's disproved, and my client actually wins and everything else? Nothing happens to the driver. If it's an unemployment situation, he has to pay back anything he was given under unemployment. But there's never any actions against him from a contempt of court perspective or anything like that. And same thing with the civil courts. I've seen it time and time again. Claimants can lie on the stand. You can demand that they produce their tax returns. They don't do it. The courts don't do anything to them. They let them get away with it. So that's something you have to keep in mind going forward. So when you have these unemployment claims, if you're gonna lose at the first round, you have to make sure that you get as much information on the record as you possibly can before it goes to the next level. The next level is going to be an appeals board, which could be 3 judges. Sometimes they're actual judges, sometimes they're lawyers, but it'll be 3 representatives depending on the state you're in. Sometimes it's a single representative, but they will look at the transcript of the initial ALJ case. Sometimes they will call for a hearing if they don't feel that the transcript fully gives them a good picture of what happened or what the situation was. But more than likely, they're going to review the transcript of the ALJ, and then they have a decision to make. Do they agree with the ALJ and uphold the driver's right to collect unemployment, in which case they run the risk of you are going to actually take it to a real court, a real judge at the state level, and if you win at that level, it could have an adverse effect on the agency overall, because obviously that case that you just won is going to be used as an exhibit in all cases similar to yours going forward. So they have to be very careful what they're going to actually risk sending to a court. One thing that does play in their favor is that in order for you to get to that court, you're going to have to pay the assessment. So a lot of times through the course of this whole thing, they will make a ruling on a single driver, and then they will get you a bill for all similarly situated drivers, an audit assessment, saying that now you owe $200,000. So they're going to say, in order for you to get to court to defend this single claim, you're going to have to pay the $200,000 assessment in order to even be heard in court. And that's a very, very tough thing for a lot of companies to do. So if they uphold the ALJ's decision, they run the risk of him taking it to you taking it to court. If they reverse the decision, they'll send it back down to the ALJ level for another hearing. That sends a message through to the ALJ that this isn't a very good case. You better take a look at this a little bit harder. A lot of times the ALJ at that point will rule in your favor, and the case will be over with. So in the solution here, you want to make sure you have a very well written contract. It reinforces to the driver continually that he is an IC. He negotiates his rates. You just don't dictate them to him. He pays his own expenses. You never pay his expenses. Don't let him drive your vehicle, your forklift. Watch what you say to drivers and how you say it. Verbiage is key. If it comes down to an equipment scenario, and I know a lot of people on this call were moving and storage folks, it's hard to find somebody who's an independent contractor that might have the equipment that fits your needs. If you own the equipment the driver would need to get the job done, you can rent them that equipment, or even better is a lease with an option to buy, an equity-based lease that shows that he is bearing the expense of operating that vehicle. So obviously he's going to want to negotiate for a higher rate, which is going to basically come back to you in the form of the rental on the vehicle or the lease on the vehicle. It's pretty much a wash in that aspect, but he will be taking some financial responsibility for that particular truck. Now we're going to talk about civil actions, and the civil actions are probably your worst nightmare. Used to be in the old days, class action cases, they were held out for the FedExes of the world and the IBMs and the very large companies. Well, all those days are gone. Now it is so easy to file a class action collective bargaining case. Any little boutique law firm, 1-2 person law firm, it's basically a very simple. They find one lead plaintiff, one named plaintiff, and they're not supposed to advertise, but believe me, they find them through their network of friends. They name that person, and they say all similarly situated people. They didn't get meal breaks. They weren't paid overtime. They didn't get this. They didn't get that. They file that case, and then it's up to you to have to defend that case and prove those allegations wrong. And that can be an extremely costly endeavor. The price alone for the discovery section of this could run you hundreds of thousands of dollars, depending on what it is they ask and demand in discovery. They're going to want depositions, they're going to want records, they're going to want emails, they're going to want everything they can possibly think of to throw at you to make it look like it's going to be such a costly endeavor. You're going to say, what's it going to cost us to provide all this information, and then what if we lose, versus if we just settle with the guy and cut this thing off and get it done with. And they're hoping you settle because they don't want to go through court. And if they do, want to go through court, that's very rare. They want to try to get that settlement quick. And believe me, the drivers get a very, very small amount of the amount that they get in any settlement. If you're at all familiar with the Uber case that happened recently in San Francisco, Uber basically agreed to pay a settlement, and the particular class action law firm that was involved in that, I've actually been up against several times in several different cases. The judge said, wait a minute, now here's the settlement amount, but the drivers are only going to get a very small percentage of that. I think it was somewhere in the vicinity of 15 to 20% of the total settlement. And the lawyer said, well, we put all this hours in and all this time in, and we're entitled to get paid for that time. And the judge said, no, I don't think I'm going to approve this settlement. So he didn't approve the settlement. So they had to go back to the drawing board. And that's basically these attorneys. They're very greedy in the way that they go about these, and they tell the drivers that they're going to make millions of dollars, and everything's going to be right with the world when they're all done. When in actuality, the lawyers are going to get richer, and then they're going to move on to another case. And a lot of times you could settle with this particular law firm and these claimants, and then 6 months later they show up with a different claimant, and you're back at it with them all over again. And they already know enough about your company that they can even delve further into the discovery phase. So these class actions are very dangerous. They can be brought by a 1 or 2 man firm. Once they get approved by the court to move forward, they'll basically sell it up the line to a larger law firm and just basically be promised a percentage of the total settlement when it finally happens. So the solution here would be, have a solid contract with some simple, very easy to understand arbitration language, which will prevent a collective action and deter a lawyer from bringing a case. Arbitration clauses in contracts have been upheld more than I can even believe in the last few years, and even in the Ninth Circuit out in the West Coast, where these arbitration clauses are standing up. Now, when you do your arbitration language in your contract, obviously you have to have your attorney help you with that language, or draw it up himself. Don't make it too complicated. Don't make it too long. There was a case some time ago, I believe it might have been FedEx, where the arbitration language was like 7 pages long, and the judge just looked at it and said, listen, here I have a claimant in front of me. He's got a 10th grade education. You're expecting him to understand 7 pages of legalese where, I've got a Harvard law degree and I had to read it twice. So make it simple enough that the driver can't say I didn't understand what I was signing. And a lot of times those cannot be upheld. And then that really deters the lawyers, because now all of a sudden they have to take each individual driver and go through arbitration. And arbitration is usually a split the baby thing. So they're not going to get close to the amount of money that they wanted originally. And so they don't want to pursue those claims. So even if the arbitration clause is in there and a lawyer looks at it, he might say, let's pass on this one. Let's move to some lower hanging fruit. But I can't emphasize this enough. Good contracts are like good fences and good neighbors. So make sure you protect your company. The IRS. The IRS back in the 80s was the menace in the transportation industry. They were auditing people left and right. It basically came down to a situation where just about everybody I knew was being audited. I actually got audited in 1983, I believe it was. The audit went on for a year. I had about 350 drivers at the time. After a year of battling it out with the IRS and losing sleep and everything else, I ended up getting a no change letter from the IRS. You'd think I'd be delighted with that, and I was. Except it cost me a lot of money to get there, and lo and behold, in the course of that year, my density had grown to a point where mathematically it made more sense for me to actually go out and buy vehicles and hire employees, and I could make a bigger margin. So through the course of that whole process, I ended up turning into an employee operation anyway. So if you make a serious attempt at trying to do things right, the IRS will usually give you a pass. They're really not out to try to find people and rake them over the coals. Those days are kind of gone. But with the IRS, just like with any other agencies or any other claims, you got to have a solid contract which clearly identifies the driver as an IC, not an employee. Have the driver's rights clearly spelled out, that he has all these rights to accept or reject, negotiate his rates, and so on and so forth, set his own routes. That they have to file a business tax form, Schedule C. And that anybody who is treated like an IC gets a 1099. And don't go by that rule. Well, if they don't make more than $600, I don't have to give them a 1099. So you pay them $595 and say I don't have to give the guy a 1099. Give everybody a 1099. That costs you a couple of bucks, and you don't need them digging into those small claims to try to find something. State audits can be a little bit trickier. The states are all broke. They need to raise money. The easy way for them to raise money is to say, well, you know what, we don't believe the independent contractor model is a legitimate model. We need to go out and find some money, so let's go out and assess these people. So if you're not in that 2% random poll, they will take these individual claims and use them as the triggers to come out and take a look at your operation to see if you in fact you're doing anything that should be deemed to be skirting the tax laws. And it's amazing how many assessments they'll just go out and hand out that aren't contested, and people just pay them. And from an auditor, from a state's perspective, they send an auditor out on a field audit, and he spends 8 hours on a particular job, and they hand out a $100,000 back tax bill, and it gets paid. Well, that was a good day for the state. They made a lot of money, and they're very happy. So if an auditor does come in from the state, call your accountant. Don't let them deal with you don't want to deal with the state yourself. A lot of times these guys will walk in the front door. They'll ask to speak to somebody. It'll either be a receptionist or it'll be a dispatcher if the owner's not around. They'll ask a bunch of questions. They'll say, how many drivers you got? How many are independent contractors? They'll get their answers. They'll turn around. They'll leave. They'll write up a report, and they'll send you a tax bill for hundreds of thousands of dollars sometimes. And then all of a sudden you have a problem on your hands. So make sure that if they do come in your door, someone informs them that this is not a good time. We're gonna have to make an appointment to get back to you, to get those records, get his card, contact your attorney, contact your accountant, let them set it up, have the meeting with the auditor off-site. Make sure that the drivers any drivers that are using your vehicles, they have a legitimate rental agreement or an equity-based lease signed, and if you follow all the rules, hopefully you should be okay. So in a nutshell, you got to have a solid contract. You have to have the proper insurances in place, which would be occupational accident, contingent workers' comp. Get professional advice. Don't rely on what you've read on the internet to give you the guidance you think you need to do this right. Make sure that your attorney's on board, your accountant's on board, they know what you're doing, and make sure that the people in your operation know what is going on and why it's so important. When we come down to the next piece here, the free from direction and control, obviously the drivers have to be free from direction and control to avoid being classified as an employee. Well, this is a very tough thing for a dispatcher to deal with sometimes. I mean, these dispatchers have the hardest job in your company. They have basically 3 people they have to answer to, and 1 being the ownership, 2 being the customers who are shipping, and 3 being the drivers. And they got to try to keep everybody happy. And at 2 o'clock on a Friday afternoon, a dispatcher could tend to be a little bit more directive than he should, and those are the times when it'll come back and bite you. So make sure that everybody in your operation understands the fact that it's so important to treat these people like independent businesses rather than employees. And I used to tell my dispatchers, I used to say, the biggest difference between an employee and an independent contractor is the word please. Because if you say to him, go do this now, that's direction. If you say, could you please go do this now, that's a question. So make sure that everybody's on board with the fact that it has to be done right. And if you get involved in any kind of hearing, make sure you get all your facts on the record as soon as you can, as early as you can in the process, so that they can be referred to later when it's reviewed by somebody higher up in the organization. So, with independent contractors, it's not illegal to use independent contractors. One of the largest users of independent contractors in the United States is the U.S. Postal Service, and I know that because I used to be one back in 1980. But just calling them an IC and having a contract is not enough. You really have to talk the talk and walk the walk. And your defense is only as good as the way your brand new dispatcher dealt with that litigious driver on a Friday afternoon. So always remember, these drivers are sole proprietors, independent business people, and they need to be treated as such. They need to participate in rate discussions, bear their own expenses, not be told to do something but asked. You can train them, but you can't make them punch a clock. You can't train. Well, I should say you can train them for customer-specific needs, but not your specific needs. So if a customer says, you're handling these meds, or you're handling this hazardous material, or whatever you're handling, and that you have to have training in order to do that, that's customer specific training, and that can be performed, but just got to be careful the way you do it. They don't punch a clock. You don't dictate their routes. You don't tell them how they have to go. They have to make that decision themselves. And it's tough for your dispatchers, but really it's a small price to pay for a flexible workforce that actually meets your needs. So thank you very much for attending today.